Real estate agents are licensed professionals who represent buyers and sellers in real estate transactions. Agents usually work completely on commission, so their income depends on their ability to assist clients and close transactions. Agents are required to work under a broker who has additional training and licensing to own a real estate company. Brokers are sales agents too, but also perform the role of a supervisor by overseeing the compliance of agents and purchase contracts. Both are members of the National Association of Realtors and have access to the Multiple Listing Service, referred to as MLS. In most states, the agents can represent both the buyer and the seller, but must disclose their representation so the buyer and the seller are aware of any conflicts. It's important for the buyer and the seller to know that the real estate agent performs different duties for the buyer than it does for the seller. The best place for the buyer to find a great real estate agent is through their loan officer. Your loan officer works with many agents and knows who has the integrity and the knowledge to effectively represent buyers. Traditionally, the seller pays the agent's commissions from their closing proceeds, but they could also be split with the buyer if negotiated. The industry standard has been 6% sales commissions, 3% to each agent. However, this is changing due to online listings and higher priced homes. Now agents are willing to negotiate the commission or charge a flat fee that is much less than the regular commission. Another big contributing factor is market conditions in favor of the seller versus the buyer. You may hear the agent say this is a seller's market and you'll have to offer full price and purchase the property in current condition. Some listing agents will post a coming soon sign on a property, getting buyers lined up to put in their offers before the home is even officially listed on the MLS. The marketing time and efforts are minimal for the listing agent and may not warrant a full commission. But as market conditions change and homes are harder to sell and require more marketing time and resources, efforts will warrant the standard commission. One of the most important jobs of the real estate agent is the preparation and negotiation of the purchase contract. Each state's residential purchase contract and city disclosures are different, but there are also many similarities.
I'll be using the California contract for this review. It's an 8-page residential purchase agreement and a 2-page buyer's inspection advisory. Paragraph 1 covers the offer information. Make sure that you give your agent the same legal name with initials and suffixes that you gave to your loan officer. It's very important for the names to match. The close of escrow can be a specified date or calendar days like 30, 45, or 60 days. Your agent should have a good idea based on the conditions of the property and the market conditions as to how long the escrow should take, as well as your preferred timing. If more time is needed due to unforeseen circumstances, there is always the option for the buyer and the seller to extend the escrow date by signing an extension agreement. Paragraph 2 is where the agents list the names of their brokerage firms and who they are representing. It shouldn't be a conflict of interest if the agents work for the same brokerage firm. However, having your own agent representing you is your best option. Paragraph 3 covers the financing terms. 3A discusses the initial earnest deposit. The deposit indicates your intent to abide by the terms of the contract and close the sale. The buyer shall deliver the deposit directly to the escrow holder by personal check or wire transfer within 3 business days after acceptance. The size of the deposit is usually determined by market conditions and local custom, except for specific types of sales, such as probate sales or a new housing development sale, where only a minimum deposit is required. In a hot market, you might want to make a larger deposit than you would have if you weren't potentially competing to show your sincerity to the seller. The deposit will become part of your down payment when the sale goes through. Deposits are refundable if you are unable to satisfy a contingency after exercising due diligence to do so. The contract should include contingencies for inspections like pest, roof, contractor, septic, well, etc. and a satisfactory condition of title to the property, also your ability to get your mortgage approved, and your lender's approval of the appraisal and property value. If any of these contingencies come back unsatisfactory and can't be negotiated with the seller, your deposit should be returnable once both parties have signed the release form indicating how to disperse the funds and cancel the escrow. 3B, an increased deposit may be required after all contingencies have been removed to show additional security to the seller. Paragraph 3C, loan information, should be obtained from your loan officer by your agent, including a request for a pre-approval letter with verification of funds to close. This takes us to section 3, G, and H. The contract gives the buyer 7 days after the acceptance to provide the written verification of down payment, closing cost, and a pre-approval letter from the lender. But in most cases, it is better to include it with the initial offer to show the strength of the buyer. I suggest checking the box "Letter attached." The letter can be updated within 7 days to match the final negotiated price. I don't ever suggest you give your agent a copy of your bank statement to verify your funds up front with the initial offer. This could hinder your negotiating power by divulging too much information to the seller. Your loan officer can verify the exact funds and the institution name where the money is held without divulging the full balance in your accounts. Paragraph 3, H3 is the loan contingency removal and allotted time for the loan to pass through underwriting, and the loan officer to confirm that the buyer can meet all of the prior to doc and prior to funding loan approval conditions. Section 3I is the appraisal contingency removal allotted time. I suggest you check the box that keeps the appraisal contingency separate from the loan contingency, or it will automatically be deemed removed when you release the loan contingency. Paragraph 4, allocation of cost are determined by your area's customs. Your agent will recommend what you should pay and what the seller should pay based on custom, but you have the option to ask the seller to pay specific cost, which they in turn can counteroffer. I completed this section with a customary example. Paragraph 5 gives more detailed closing and possession dates and times, depending on how the house is currently occupied. Paragraph 6 discloses the buyer's statutory due diligence along with the attached 2-page Buyer's Inspection Advisory. The buyer should take the time to read and understand their rights to inspect the property they are purchasing. Paragraph 7 gives the seller a timeline to disclose if the property is in a condominium or planned unit development. It also gives the allowed time to provide you with all the documents that you need to review prior to removing your contingencies. Paragraph 8 specifies the items included or excluded from the purchase price. The stove, refrigerator, washer, and dryer are the only personal property that can be included in the sales price. All other personal property transferring from seller to buyer cannot be included. I'll repeat that, cannot be included in this agreement. Paragraph 9 discusses the buyer and seller's due diligence to inspect and disclose the condition of the property. Paragraph 11 indicates the seller's property questionnaire as checked, requiring the seller to complete the form and deliver it to the buyer for review prior to removing the contingencies. Paragraph 12 covers title investing. It's important for you to know that the manner in which you take title to the property may have significant legal and tax consequences. You should consult your CPA or appropriate professional. We do provide a list of vestings in the resource section of our website. Paragraph 14 lists the time periods and dates to remove contingencies and cancellation rights. Repairs must be completed as a prior to funding condition of the loan. In a case that prevents immediate repairs, like winter weather conditions, the lender may allow for an escrow holdback for repairs to be completed after the close of escrow. 1.5 times the cost of the repairs will be required to be held by the escrow company until the repairs have been completed and inspected. Close of escrow means the date the grant deed or other evidence of transfer of title is recorded. Contract days are always calendar days. Paragraph 25 outlines liquidated damages against the buyer's deposit if the buyer fails to complete the purchase after all contingencies have been removed. Your agent will be working hard to make sure that you stay in the parameters of the contract. Paragraph 29 includes the date and the time that the offer expires. Paragraph 30 includes either the offer acceptance, the counter offer by checking the proper box, or the rejection to the offer at the bottom of the page. You'll want to read the buyer's inspection advisory as it is packed with information about the buyer and seller's rights, the property investigation, the broker's obligation, and much more. And that covers the details of the purchase contract and the agent's great responsibility.
Thank you for watching, and here's how you can help us. First, share us with your network on Facebook, Instagram, Twitter, and YouTube. Secondly, tell your family, friends, and coworkers about us. And lastly, we are publicly funded and need your help keeping our videos free by clicking on the Support tab today. Don't miss the Tips and Timing video, found only on our website, for all the ways that you can save hundreds of dollars when buying a home.